Here are the topics that will be covered within the Supreme Court revision video. This video is going to focus on the checks the court can perform on the legislative and executive branches, as well as how the Supreme Court can be controlled. Not only does the court rule on the rights and liberties guaranteed in the various amendments to the Constitution, but it also from time to time rules on the power of the other branches, Congress and the executive branch. Before I go through these checks and balances, pause the video here to write down all the checks of the Supreme Court against Congress and the Presidency and vice versa. Let's start with checks on Congress. The United States Supreme Court has held about 180 acts of Congress as unconstitutional. For example, in the 1997 case of Reno versus the American Civil Liberties Union, the Supreme Court declared the Communications Decency Act of 1996 unconstitutional, as it violated the Freedom of Speech Amendment. This was about criminalising the knowing transmission of porn to minors. This has also been seen in the Affordable Care Act, otherwise known as Obamacare. Democrats argued that the Affordable Care Act could be passed under the Commerce Clause, as it was requiring individuals to purchase health insurance. Critics argued that the provision requiring individuals to purchase health insurance or pay a penalty was outside of Congress's power to regulate commerce. The rallying cry of critics became, if Congress can make you buy health insurance, they can make you buy broccoli. This led to the Supreme Court to intervene, thus conducting a check. Judicial review includes the power to declare actions of any member of the executive branch unconstitutional, including the President. Let's look at some examples. The United States versus Texas in 2016 blocked Obama's immigration executive order, the Deferred Action for Parents of Americans and Lawful Permanent Residents. This basically allowed parents to stay with their children if they were American citizens. Another example is Bush and the Guantanamo Bay detainees. The Supreme Court has struck down some important parts of the Bush administration's legal policy regarding its war on terror. Raskol versus Bush in 2004 ruled that foreign detainees held at Guantanamo Bay did have access to the United States federal courts to challenge their detention. Hamdan versus Rumsfeld in 2006 was declared unconstitutional as the military commission set up by Bush to try people held at Guantanamo Bay violated the Geneva Convention. This put a significant limit on the commander-in-chief power of the president, even in a time of war. Another example is Obama and recess appointments. Article 2, Section 2 states that the President shall have the power to fill up vacancies that may happen during the recess of the Senate. In the National Labour Relations Board versus Noel Channing in 2014, the Supreme Court ruled that Obama made the executive branch appointments at a time when the Senate was technically available to give its advice and consent. Obama made 3 appointments to the NLRB during a 20-day period when the Senate was convening every 3 days. Thus, the court also ruled that the NLRB ruling against Noel Channing was void. Even 2 of Obama's own appointees, Sotomayor and Kagan, ruled against him on this matter. What about checks and balances on the Supreme Court itself? We can call this congressional control and look at the checks that the legislative branch can perform. The Senate has confirmation of appointments, which counts as a check. Congress decides how many justices there are under Article 3 of the Constitution. There is also the power of impeachment. For example, Judge D. Thomas Porteous was a federal judge who was found guilty on 5 articles of impeachment, which was bribery, by the Senate in December 2008. It can also be a forum for public opinion and pressure, which acts as a supreme check against the court. Congress can also amend the Constitution, which affects the Supreme Court's interpretation of it. Constitutional amendments are the ultimate legal weapon available to Congress. 4 out of 27 amendments have been overturned by Supreme Court decisions. The 14th Amendment nullified Scott versus Stanford in 1857 by guaranteeing the civil rights and citizenships of African Americans. The 26th Amendment negated Oregon versus Mitchell, 1970, by permitting 18-year-olds to vote in state elections. What about presidential control then? What checks can the executive perform on the Supreme Court? Well, they can nominate justices, challenge the balance of the court. For example, Nixon pledged to replace the liberals on the court with strict constructionists. They can also support or criticise a decision that the court has made. This happened with Roosevelt when he tried to pass the New Deal. It can also suggest a constitutional amendment to Congress and also has the power of the pardon. Despite these official checks of other branches of government against the Supreme Court, there are other ways the Supreme Court can be controlled. The Supreme Court has no power of enforcement. It has to rely on people choosing to obey the court rulings. For example, with Brown versus the Board of Topeka in 1954, it ruled that Southern schools should desegregate, but by 1957 this was still not happening. The President would not be impeached if they did not obey the Supreme Court, though this has never been the case, so we do not know what will happen. Congress also does not have to follow the Supreme Court's decisions. Instead, it would probably pass another law to stop the law that the Supreme Court has override. This would also override the President's veto or the Supreme Court. Time and workload are a way of controlling the Supreme Court, as they can only review a certain number of cases. Public opinion and media can also be efficient ways of controlling the court, as well as influencing its decisions. The Supreme Court also cannot initiate its own cases. They have to wait for them to be brought to them, and this acts as a measure of control. Finally, the Supreme Court cannot amend or overturn previous decisions made by the court.